Oh, okay. We're on the matter of Plaza Services versus Angela Welch, counsel appearance.
Good morning, Your Honor. Josie Lewis for plaintiff, P69317.
Angela Welch, can you unmute, please?
Good morning, Your Honor.
Good morning. Today was the date and the time that was set for a hearing on an objection to installment payments. Did the parties meet prior to going on the record?
We did, Your Honor.
Yep.
We tried to reach a resolution, but we could not.
Okay, so Ms. Welch, you filed a request and you are requesting to make installment payments in the amount of $20 every week?
Yes, Your Honor.
Okay, it says that your average income is about $400 a week. Is that correct?
Yes, it's less than that with the garnishment as of right now.
Okay, you have a garnishment by whom? Is it this or something else?
This.
Okay, that's accurate. She has a garnishment that's in place already?
That's yes.
Okay, and then you're seeking for her to make a payment on top of the garnishment?
Well, I'm actually asking that the garnishment remain in effect, Your Honor, for a couple different reasons. One, the judgment is 4 years old. The balance is over $5,000. Her proposal at $80 a month would take 5 more years. And more importantly, Your Honor, she didn't honor the last installment payment order. She's never once made a voluntary payment on this account. So we're actually asking the court to deny her motion and allow the garnishment to remain in effect.
Okay, she makes $400 a week, and it says here you're working at Myers Stores. Is that correct, ma'am?
That is correct.
You pay $720 a month for rent.
Yes, Your Honor.
Water and utilities amount to about $450. Is that accurate?
Yes, roughly. Yes.
What are the other expenses that you have?
Well, as of right now, I also have a lien on my home that I'm trying to take care of. The difference between when I told them that I could pay versus now is that I had help in the home. My mother passed away. She was helping me with mortgage and bills. And at the time I went to court, no, I didn't make any payments because at that time is when my mom passed away. So the 25% garnishment that is being taken from my check right now is actually about 75% of my mortgage. So now I'm behind on mortgage. And I'm probably going to lose my house. Unfortunately, the reason why we're here and the garnishment and the Jeep, the vehicle, is because my ex, who is now incarcerated till 2031, he is the one that took the Jeep. I tried to call the finance company. I tried to tell people I wanted to call the cops and tell them he stole the vehicle, something was going to happen. I even helped them find the vehicle when he took it. And I feel that regardless if he's out in 2031 or not, I should not have to pay the whole debt. I feel that when he gets out, he's going to be able to walk free. And I've been paying for all his mistakes in the last 4 years since he's been incarcerated, since we broke up. I kicked him out. He took the car. I tried to get the vehicle back.
Let me stop you here. Let me stop you here. Did you sign for a loan for this vehicle?
Yes, ma'am, I did. And that's why I was trying so hard to get it back.
Then it was your mistake, not his.
Correct. Okay. And I do agree. And I will take, responsibility for that. I don't think
I only see one signature. I only see one signature on here. It was for yours. your name. Nonetheless, we're not here to dispute the debt at this point. This is a garnishment, so the debt and the judgment is what it is. We're trying to discuss how you're going to repay that. It looks like you're bringing home, is this your gross or your net $400 a week?
That's how much I bring home. Well, I
Okay.
bring home less than that now because of the garnishment. About every week, I bring home anywhere from $300 to $350.
And you're working full-time?
I am technically part-time. When school starts, I'm unable to work a full 40 hours because I have to get children to school and off the bus in the afternoon. So sometimes I'm working 6 days just to make ends meet.
Okay, I need the court with copies of 1 month's worth of check or your pay stubs, okay?
Okay.
Okay.
And how do I do?
How do you do what?
How would I do that? Is there email or fax or something?
You could drop them off if you would like to the civil department, or you can have them scanned and you can have them sent to Judge Simmons Courtroom at lansingmi.gov, okay?
Okay.
Okay, from what I see, if she's making $400 a month, I'm sorry, a week, that's $1,600 a month, and she's got to pay rent, which she says is $720, or her mortgage, she's $720, and then she has utilities and other bills, $450. That leaves her with $430. She's got to eat and do other stuff. I'm sure.
Your
And
Honor,
that's $40 for the. Oh, wait! Can you stop interrupting me, please?
Sorry.
I've heard enough.
Sorry.
Yeah, I've heard enough. I don't want to hear the background anymore. There's enough. I just need your check stubs. Let me see here. How many kids do you have?
3.
And then she has 3 kids to feed off of $400 a month. I'm going to grant her request, and it's going to be payments of $20 a week beginning September 1st. I'm going to set this for review. In 4 months, when you come for your review, I need your pay stubs to be submitted prior to the date of this review. Do you hear me?
Yes, ma'am.
And then we will suspend the garnishment during this time.
Would you like me to provide an,
Looking at what she has here, there's one that's already completed,
okay,
so I can just go ahead and sign this one here.
okay,
And then we're gonna get you a date right now for the review, 4 months out. 19th to December 19th at 2 p.m.
thank you, Your Honor.
Thank you. Any additional matters for the record today?
No, ma'am.
Thank you, Your Honor. I just have one question. So the garnishment is still be able to get out of my check, or do I need to call them and make a payment?
I have suspended the garnishment.
Okay. Okay, I understand now. Thank you.
You're welcome. So you should not be getting garnished during this time, okay?
Okay, thank you.
You're welcome.
Bye.
Thank you. Okay, let's see. Sheila Thompson failed to appear. Their attorney here on behalf of Orbit Leasing.
Good morning, Your Honor. Jeremy Chisholm, P74670 here for Orbit Leasing this morning.
Thank you. Today was the date and time set for a pretrial. Sheila Thompson, the defendant, has failed to appear. How do you want to proceed?
Judge, I'd ask the court at this time to enter a default in this matter. Ms. Thompson, you filed something with the court, but she didn't file anything that was a meritorious defense. She basically just said that she was on Social Security and it wasn't collectible. So I'd ask for a default and the opportunity to present a default judgment, maybe under the 7-day rule if the court thinks that's the appropriate path.
Okay, motion for default is granted and you can submit order under the 7-day rule. Any
you, Your
additional
Honor.
matters for the record?
No, Your Honor.
Thank you. You're all set.
Thanks, Judge.
You're welcome. Okay. Is this Peoples here?
Shit.
Okay. And is Sean Lee here?
Yes.
On the record in the matter of the people, I'm sorry, of Joanne Peoples, the matter of Joanne Peoples versus Sean Lee, file number is 23-00708 LT. What is this for? Set aside dismissal. Can you hear me?
Yes, ma'am.
Okay, you're not driving, are you?
No, ma'am.
And you're Miss Peoples? You can hear me?
Yes.
Thank you. Today's the date and the time set for a motion. Ms. Lee, I believe you, I'm sorry, Ms. Peoples, you filed a motion requesting to set aside the eviction due to lack of progress. You said that you were in the hospital, ma'am?
Yes.
Okay. And so you want this reinstated so you can proceed with your eviction?
Yes.
Okay, you were here back on March 29th, I believe it was, and you wanted 30 days because he had paid most of the rent. And then I do have a note here on April 26th that you were rushed to the hospital. So my question is, has he not paid any rent since then, is what you're saying?
I'm sorry.
Are you saying he hasn't paid any rent since?
No.
Okay, okay, so I'll grant your motion. And you all want to proceed with an eviction hearing?
Yes.
What's our next available? Actually,
I thought
I'll
the
proceed today.
eviction had already been ordered.
it was not. And the reason why it was not was because on the 29th of March, you requested to give him 30 days. Because at that time, he had paid most of the rent.
But we had a hearing since then.
Not on this matter. On April 26th was our next court date, and my note was that you were rushed to the hospital and the defendant failed to appear. So there was a default. But you never filed the default. That's what the issue was. We didn't get the paperwork.
At that point,
Oh.
I was supposed to file the default.
Yes, once he defaulted, you have to submit the default paperwork signed so that we can get the file
That's
defaulted.
when I was hospitalized.
You were rushed to the hospital. Mr. Lee, why did you fail to appear in court on April 26th?
Quite honestly, I didn't know about it. I've had previous issues with my mail. That I totally take responsibility for that. With the situation as it stands, I'm in the process of getting the house cleaned up and moving out right now. So I like I said, I totally understand. This is my fault. I had a few health issues that unfortunately couldn't be overlooked and had to have those taken care of. So like I said, I'm in the process of getting everything cleaned up and moved out right now.
Okay, well, you were supposed to be out the property already, and you can't give an excuse that you had an issue with your mail because I verbally gave you your next court date back on April 29th. I told you what your next court date was gonna be.
No, ma'am. I wasn't in court on April 29th.
Oh, so March 29th is what I'm talking about. April 26th, you didn't appear.
Correct, because I had met with Joan and she said that she gave me the 30 days. So it's my misunderstanding and I apologize. That's why I didn't appear. So I apologize about that.
Maybe you're misunderstanding. You had two court days. There was a March 29th court date, then there was an April 26th court date.
Okay, and what, and I can't, I understand what you're saying, and I wasn't at neither one of them, and I apologize about that.
Okay, sounds good. Okay, so I'm gonna set aside the dismissal because Ms. Peoples, you were hospitalized. You did previously have a valid motion for default. Default will enter. You're all set, Mr. Lee.
Okay, thank you.
You're welcome. You can help her
Bye-bye.
complete the paper. Absolutely. What an immediate writ. Okay. On the record in the matter of portfolio recovery versus Barbara Almeida.
Good morning, Your Honor. For the record, Christine Richter, P61525 for the plaintiff.
Thank you. And is Barbara Almeida here?
Yes, I am, Your Honor.
Okay, and my understanding is that the parties have met and there is a conditional dismissal that's been worked out. Is that correct?
That's correct, Your Honor.
Okay. Counsel, can you put the terms on the record?
Yes, Your Honor. The balance being paid by defendant is $733.41. That balance will be paid in monthly installment payments as follows. 14 payments of $50 a month and one final payment of $33.41. First payment will be due September 15th of 2023, and all subsequent payments will be due on the 15th of each month thereafter until that balance is paid in full. There will be a 5-day grace period for each payment. In the event of a default, my client would have the right to file an affidavit of noncompliance with the court, which would allow the case to be reinstated and allow my client to obtain a default judgment for the remaining balance plus court costs, which are not being added at this time.
Okay, Ms. Almeida, is that accurate that you want to enter into a conditional dismissal to resolve this matter?
That is correct, Your Honor.
Okay, so that means that you're agreeing to have the dismissal entered today under the agreement that you'll make payment in the amount of $733.41 and 14 payment installments of $50 per month, and the last payment being $33.41. Each payment due except the 15th of each month, first payment being due September 15th, and there's a 5-day grace period. Is that your understanding of the agreement that you're entering into?
Yes, Your Honor.
Also, the plaintiff is agreeing not to add court costs at this time. However, if you default, they have the right to seek a judgment against you and also assess the court cost at that time. You understand that?
I
You have
understand.
the right to be represented by an attorney today. Are you waiving your right to be represented by an attorney?
No.
You're not waiving your right to be represented by an attorney. You want an attorney to represent you, ma'am?
I'm not even sure.
Okay, let me say it again. You have the right to be represented by an attorney. Do you understand that?
Okay, yes.
You appeared here without an attorney today. Are you waiving your right to have an attorney represent you?
Yes.
Okay, and you have the right to proceed to a trial in this matter. Are you going to waive your right to have a trial so you can move forward with this agreement?
Yes.
Anybody threatening you to get you to waive your rights and enter into a conditional dismissal agreement?
No.
Has any promises been made to you that wasn't stated here on the record to get you to waive and enter into a conditional dismissal?
No.
You have 3 business days from today. If once you leave here, you realize you misunderstood any of the rights that you're waiving, you can request to have this matter set for a next court date, okay?
Okay.
Partial performance under this conditional dismissal will not satisfy the agreement. You understand that? You have to perform in full according to the agreement that you're entering into. You understand that?
But I'm sorry that I have to what?
Partial performance under this agreement will not satisfy the conditional dismissal. You have to perform fully under the agreement. You understand that? You
Yes,
can't make some payments and not make the others. You can't make them late. You have
Right.
to comply completely with the agreement. You understand that?
I understand.
Do you have any questions right now?
No, Your Honor.
Are you giving Attorney Richter the permission to sign the conditional dismissal on your behalf?
Yes.
Okay, and so Ms. Richter, you can execute that agreement and you can send it to Judge Simmons' courtroom at lansingmi.gov for me to review and sign.
Okay, will do, your,
Thank you. Any additional matters for the record?
no, Your Honor.
Okay, you're all set for today. Thank you.
Thank you, Judge.
Thank
Have a great day. Thank you, Miss Almeida.
Same to you. On the record in the matter of Clifton Johnson versus H Inc., file number 23-01237 GC, council appearance.
Hey, please, on court, Stephen P. 7829, counsel defendant on this case.
Mr. Johnson, are you have an attorney representing you?
No, ma'am.
Okay, so today was the date and the time that was set for a pre-trial.
Your Honor,
Did the parties complete or?
got some notes here. I'll submit after the hearing today, if that's okay with court, an actual joint pretrial statement. I ran through the list with him in the breakout room. We are going to ask for 90 days with the discovery. And what I'd like to do, he's an over-the-road trucker. Normally it was 28 days for response and discovery. I'll bump it to 35 in case he's not back in time. So I'll modify the information on that.
Okay.
It's going to be a half-day trial, and we will ask the witness and exhibit list be submitted after like a week after discovery is closed, or however the court wants to handle that.
Okay, sounds good. Mr. Johnson, is that accurate as to what the council has stated?
I want to say so. I just heard the 90 days. I didn't hear the 35. So I have questions about the 35. Do I have to bring witnesses within the 35 days or?
No, sir, on discovery, you have 28 days to respond when I send you something by court rule. I'm asking the court to let me change that to 35, give you an extra week because you're an over-the-road trucker and you may not be back in where you gave me the Lansing address. I won't say it on the record unless George wants me to, but you gave me the Lansing address to mail stuff to. And if you're not there in 2 weeks because of your job, I don't want you to be penalized because of your job that you didn't get a chance to have the full 28 to respond to it.
Do you understand that, sir? Do you
Yes,
understand
ma'am,
what
I do.
discovery is?
No, ma'am.
Okay, so discovery is the opportunity that the parties have to request certain information or documents from each other pertaining to the litigation, okay? So
Okay.
he may submit a request on behalf of his client to you for certain documents or information, and you would have to respond within that 35 days. You understand that?
Okay. Yes, I do.
Okay, and I was going to bring up the address issue because do you live in Jonesboro or do you live in Lansing?
My address is in Jonesboro, but I come back and forth to Lansing. I'm more
Okay, so you're
in
gonna be able
Lansing.
to receive, you're gonna be able to receive your court dates to the Jonesboro address or the Lansing address?
Either one is fine.
Okay,
Put that on the record then, Yara?
you don't have to put on the record, but you can give it to me when we're off the record because I am live streaming. The other issue is your trial is gonna be in person, not via Zoom. You understand that?
Yes, I do.
Okay, so you're gonna complete the joint pretrial statement and file it with the court counsel?
Yes, ma'am.
Okay, do you have any questions today, Mr. Johnson?
No, I don't.
Oh, any additional matters for the record?
No, ma'am.
You're all set, Mr. Johnson.
Thank you.
You're welcome. You're all set, thank you.
I'm gonna give you the
Yes, if
May I
you could
approach?
just, yes, you can approach. Thank you.
Thanks so much.
Have a good one.
You too.
What is going on here? Let's strip it out. Okay. On the record, in the matter of LVNV Funding LLC versus Christie Hall. Is Christie Hall present? Okay, counsel appearance for the record.
Good morning, Your Honor. J. Latif Beg, BAIG, P 36820. Appearing on behalf of plaintiff.
Okay, today was the date set for a motion for summary disposition filed by the plaintiff. We never received a response from the defendant, and the defendant has failed to appear.
Your Honor, may I, there has been a settlement. I was hoping that Ms. Hall would appear today so she could sign a conditional dismissal form. I am not inclined to default her.
Because you've already negotiated the settlement.
Right, and she
You
may
can
be
reset
relying
it.
on the fact that,
Agreed. I can reset it to give you time to see if you can get that completed.
or,
And then if not, we'll move forward with this motion.
Your Honor, I know it may be pushing it out a bit, but according to the terms for final payment would be October 25th of this year. We could push everything out after that date. And then maybe she completes her payment, we just file a dismissal.
Sounds good.
Thank you.
After October 20.
After October 25th.
November 2nd at 10 a.m.
November 2nd at 10 a.m.
Thank you, Your Honor.
Thank you. Any additional matters today?
No, Your Honor.
Okay, all set. Thank you.
Am I gonna get a notice or are you just gonna mail out the notices?
I'll give it to you.
Thank you for that. There's that. On the record, in the matter of Mary Comfort versus Michigan Catholic. File number is 23-01-581. Who's here for that? Where is she? Oh, okay, well, we'll call that case. It's a pretty good file, actually. Okay, on the record, in the matter of James Lawler versus Dale Brower, file number is 23-00094. Okay, LVMP was also set for bench trial, correct? I can cross that one. What's your name, sir?
James R. Lawler.
James,
R. Lawler.
and your name, sir?
Dale Brower.
Okay, and you all are here for a small claims appeal, is that correct?
Yes, ma'am.
Okay, you discussed this matter and you haven't come to resolution?
You won't discuss the matter, ma'am.
I don't own the property. My brother-in-law does, and I plow snow for him. I put it on his land and he's trying to sue me for it.
Okay, so you guys need to have a hearing. You can have a seat and I'm gonna go off the record and handle something else before I start your hearing. You can have a seat. Ready for your hearing. Okay, Ms. Till is here. On the record in the matter of VTP Capital Village versus Ursuline Celio, file number 23-01604, council appearance.
Hi, good morning, Your Honor. Mark Wasbury on behalf of plaintiff.
Good morning, Your Honor. Felicity Till appearing on behalf of the defendant Ursuline Celio.
Okay, today was the date and the time that was set for a hearing for non-payment of rent, but my understanding is that there is a conditional dismissal that's been worked out.
There is,
Yes.
Your Honor.
One of the attorneys put the terms on the record.
Yes, Your Honor. The total rent to retain is going to be $1,840.30. No court costs are being sought. Ms. Celio has agencies that are going to help her pay the balance short of $110.30 copay. That copay is to be paid by next week, August 24th, and the agencies will have 30 days to provide their payment to plaintiff.
What was the copay again?
$110.30.
Okay, and she's gonna pay by when?
8/24.
She said she's got it today.
She does have it today, but we agreed to give her until that time to pay.
Sounds good. Okay, any other terms?
No,
No.
Your Honor.
Okay, so Ms. Celio, you understand that you had the right to have a trial in this matter?
Yes, ma'am.
Okay, and you willing to waive a trial in order to enter a conditional dismissal?
Yes, ma'am.
Okay, anybody threatening you or making any promises to get you to waive that right? You also have the right to be represented by counsel, and you are represented by Ms. Till from the Legal Services Office. And so you are willingly entering into a conditional dismissal whereby the case will be dismissed today, and you agree to pay the balance of $1,840.30. No court costs will be sought at this time. You do have assistance coming from some agencies, and you'll pay a total of $110.30 by 8/24, correct? Okay. And then, Ms. Till, are you gonna execute an agreement and submit it to the court, or is Mr. Wasbury gonna do it?
I will be submitting it to the court. It should actually be in your inbox in a couple of moments.
Okay, sounds good. And did you need us to get Ms. Celio's signature, or did she give you permission to sign on her behalf?
I have permission to sign if I can confirm that on the record. Ms. Celio, I have your permission to sign this document?
Yes, ma'am.
Thank you.
Okay, ma'am, you have 3 business days from today. If you leave here and realize that you misunderstood any of the rights that you waived in order to enter this agreement, you can return to the court and request to have this agreement set aside, and then we'll set your matter for hearing, okay?
Yes, ma'am.
Okay, do you have any questions?
No, ma'am.
Any additional matters for the record, counsel?
No, thank you.
Nothing for defendant, Your Honor.
Thank you. You're all set, ma'am. Thank you. I think that she said we should already have her Ms. Celio's paperwork. She might want a copy. I think that's what she's probably. Okay. Condition. If you have a seat, we can get you a copy of your agreement.
I just sent that email over, Judge, so you should have it shortly.
Thank you. On the record, in the matter of Monopoly Apartments versus Christina Hernandez, file number 23-00668 LT. Appearance, please.
Thank you, Your Honor. Good morning. Sam Dua here on behalf of plaintiff.
Okay, and Ms. Hernandez, can you unmute, please?
Oh, yes, I'm sorry. Hello.
Say was the date and the time that was set for a hearing on a motion to stop eviction. Let's see, it looks like we were here back on June 21st. Parties entered into consent judgment, and you, Ms. Hernandez, were supposed to pay the amount before July 7th of $2,040.82. You filed a motion on the 31st of the month indicating that you had gathered the funds owed, but you were told it's up to the courts, and you were looking to pay the balance or more time on your notice of eviction.
Yes, ma'am.
Your Honor, may I be heard just briefly to expedite the matter because we have come to a resolution?
Okay, yes.
Thank you, Your Honor. I apologize for interrupting. Your Honor, I met with the defendant in a breakout room, and it looks like she has substantially vacated the premises. The agreement is now that she will vacate on or before 5 p.m. this coming Monday, the 21st. The order of eviction can be reinstated if she's not out by the morning of the 22nd. And the defendant has agreed to relinquish the 1 month rent that is in escrow to the plaintiff.
Okay, Ms. Hernandez, is that agreement accurate?
Yes, ma'am.
Okay. You'll vacate the property no later than 5 p.m. by August 22nd. Is that correct, Mr. Adua?
21st, I believe, Your Honor. Yes, Monday's the 21st.
Monday's the 21st, okay. And that you're agreeing to relinquish the 1 month rent in escrow over to the plaintiff, correct?
Yes, ma'am.
Okay, Mr. Dua, can I get an order under the 7-day rule?
Yes, Your Honor.
Okay, I'll note that in the file, and then the writ can reissue if necessary if she fails to vacate according to the agreement. Any additional matters for the record?
Nothing further, Your Honor, from plaintiff. Thank you.
Thank you.
Thank you. You're all set, Ms. Hernandez.
Thank you. Bye.
You're welcome. On the record, in the matter of Edward Rose and Sons versus Theophilus Harvey, file number 23-01267. Counsel, can I have your appearance?
Joseph Lucas, P59595, appearing for the plaintiff.
Okay, and then Mr. Harvey, your name for the record.
Theophilus Harvey.
Okay, today's the date and the time that's set for a pretrial on a general civil matter. Did the parties come to a resolution or complete a joint pretrial statement?
I think we have come to a resolution, Your Honor. I know that Mr. Harvey was sent a document yesterday by our office, but I think I have come up with a better solution for our issue. And so I just sent Mr. Harvey an updated stipulation and order for dismissal. I don't know if he's had a chance to review that yet. Have you, Mr. Harvey?
Just briefly.
Okay, and I can say that it provides that the case is dismissed without prejudice, that Mr. Harvey will pay the plaintiff through our office the sum of $1,446.38 by March 1st, 2024, in biweekly installments of $100 starting September 1st, 2023. That if we don't get any payments, or if those biweekly payments are not coming in, the parties agree that to an automatic reinstatement of this case, and we may file an affidavit of noncompliance, and a default judgment will be entered against Mr. Harvey for the balance owing on the amount of $1,446.38. This way, Mr. Harvey doesn't have a judgment entered against him. That's good for his credit rating and other things. And if he adheres to the payment plan and the plaintiff is paid off, the case is finished. Does that sound reasonable to you, Mr. Harvey?
Yes.
You haven't signed anything yet from our office?
I did sign the first document that was sent to me yesterday. I signed it this morning and sent it over. And this one I can sign and get it sent over as soon as
If you authorize me, I will sign it on your behalf and submit it to the court, and then I will intercept what you've signed already and dispose of it.
Okay. Yep, that's fine with me.
Okay. Your Honor, is that acceptable?
That is more than acceptable, and so you'll get a copy of the final executed document to the court, correct?
That is correct. I can email that in today if you'd like.
Yes, you can send it to Judge Simmons Courtroom at lansingmi.gov.
Judge
Judge
Simmons.
Simmons, yes, SIMMONS, courtroom, all one word, at lansingmi.gov.
Very good, Your Honor. I will prepare that and submit it immediately. I think we're all set.
Okay, do you have any questions today, Mr. Harvey?
Is there any grace period with the payments at all?
Well, given with the speed with which our office, can move, I would say that anything within a few days of a payment date will be fine.
Okay.
Okay, can we get a more definite grace period so I can make sure that.
How about 5 days?
Okay, grace period will be 5 days. We'll make sure that's noted, okay?
Yep. I will edit the document and then submit it.
Very good. You have any other questions, Mr. Harvey?
No, that was it, Your Honor.
Okay, you're all set. Thank you both.
Thank you.
You're welcome. This is at 1 p.m. Brittany, did you call? Okay. Back on the record in the matter of Waller versus Brower, and this is a small claims appeal. Sir, you're with them?
Yeah.
Okay. And then this is a small claims appeal. You all were before the magistrate previously. Let's see what's going on in this file. Okay, Mr. Waller, you're suing Mr. Brower? Okay, and why are you suing him?
Because he is changing the natural flow of water by concentrating snow. And that snow is up against my fence. He's pushing snow some 40 feet past the driveway. And I can draw a picture on the board if you allow me. Give you a better idea of what's happening. I have videos and pictures.
You said the standing water is consuming the base of the shed, resulting in water damage to your fence posts, sheds, shed panels, and shed structure.
Correct.
Okay.
Combination of two things. This can be dismissed right now, immediately, if Mr. Brower agrees to stop pushing snow past the sidewalk. There's no need to push snow past the sidewalk. And
Okay,
push
can you
another.
explain to me what you said he's pushing snow past
Yeah,
the sidewalk?
draw.
Well, you have pictures?
I have this on. I have it on.
Well, I can't insert that into anything. I don't know what's on that. You could be given the
I got
whole-
pictures of, he owns a big garage, a house,
Well,
two driveways.
it's his case. He's got to prove it, not you.
Yeah, well, all kinds of pictures, but they're on my on this because I was told I could use a USB in court on the last.
You can't stick a USB here. You can put it in your own computer.
Oh yeah, I can do that.
Oh yeah. Yep, you're gonna have to log. Are you on the Wi-Fi?
I don't think I'll need to.
Well, you're gonna need to log into my Zoom courtroom so you can share your screen. I can see what you're seeing. No problem. Take your time. Is someone still in the breakout room? I'm gonna go off the record while they deal with. Oh, well, he wants in and see what's going on with these people. Drama set it. Yeah, I'm gonna close it right now. Can you hear me?
Yes, Your Honor.
Okay. Mary Comfort,
Present.
okay. On the record, in the matter of Mary Comfort versus Michigan Catholic and file number, Catholic Conference and file number 23-01581 GCE. Council, may I have your appearance, please?
Erica Jillick, appearing on behalf of defendant Michigan Catholic Conference.
Okay, and then Ms. Comfort, are you proceeding with our counsel?
Yes.
Okay, today was the date and the time that was set for the defendant's motion for more definite statement. You all been in the breakout room for quite some time. Did you resolve this matter?
We did not.
We did not.
Well, were you just sitting in the breakout room?
Yes.
We were, Your Honor.
Defendant, what was this from opposition to? Motion for removal to the circuit court. Okay, is there a motion also to remove this matter to the circuit court?
Yes, Your Honor.
Okay, is the amount in controversy above $25,000?
Your Honor, she requests two alternative amounts of damages. One of them is she totaled it up to $25,000.12 plus fees and costs. And then the other alternative damage that she requests is a monthly disability retirement benefit of $610, which if she were to obtain these benefits for a 10-year period would amount to about $73,294.
Okay, Ms. Comfort, is that accurate?
Yes.
That's the amount you're seeking?
That is not accurate. Unfortunately, Your Honor, the court has not received the paperwork that I filed in response to the motions.
You sent something this morning?
I did as a last ditch effort. My
Plaintiff's
response
request for
to,
lump sum payout was denied. Okay, disability. Okay, well, my question right now is, what's the amount of money you're suing for?
I am suing for a $25,000 lump sum payout of my pension, or the defendant to approve my application for disability, which amounts to a monthly annuity of $610.79.
Okay. And so you're suing for lump sum permission and all of $25,000 in counsel. You're saying that with court costs, that's supposed to take her above that? Is that what your argument is?
That, and I was going based off of her complaint where she breaks down the billing. Her total was $25,000.12. So that was just my basis.
Okay, yeah, she indicates that she has capped it at 25,000. And the annuity payment of $610 per month, but we could hypothesize that she'll live another 10 years, but we don't know that. So your motion
Correct.
to move this to circuit court, I don't think is sufficient at this time, especially based on her response to your motion for more definite statement. Now, as to your request for a more definite statement, are you indicating you're unclear as to what she's suing for?
Yes, Your Honor. Her original complaint was just very ambiguous to us. The Michigan Catholic Conference is a little confused.
Okay.
It doesn't state, in clear terms how she's disabled, when she became disabled, how she believes defendant got it wrong when they denied her application, and then upon what legal basis she is bringing her claims. We don't really even know what under she's bringing these claims legally.
Oh, and did you
And all
receive
that,
her?
excuse
Did you receive her response to your motion to more definite statement?
We did just this morning.
Okay. And does that satisfy your concerns?
Yes, Your Honor, but the court rule does not state that the response can suffice for the more definite statement. It has to be in the form of a pleading, according to the court rule.
Okay. I am, however, going to grant her some leniency because she is not an attorney. And I'm not going to require her to file any pleading. If I ask her what a pleading was, she probably doesn't even know what I'm talking about.
Yes, Your Honor.
Do you know what a pleading is, Ms. Comfort?
I believe it to be what I'm asking the court.
Yeah, but in this context, it would be your complaint and the documents that you're filing in the courtroom would be in the court for the lawsuit would be consider your pleadings. And what they're requesting is for you to amend your complaint to comport with the court rules, which I probably have a greater chance of winning the lottery today than getting you to file a complaint that comports with the court rules when you don't have any legal training to do that. And so you have filed a response that clarifies, I think, more of what you're asking. And so at this time, I'm going to deny the motion for more definite statement because you have provided additional response. If that, counsel, if you are later determined that this response, which you just received, I'm sure today, because we did, does not provide sufficient understanding, then you can renew your motion, okay?
Okay, thank you, Your Honor.
No problem. Any additional matters at this time?
None from me, Your Honor.
No, thank you.
Okay, you're all set. Thank you.
Thank you. Have a good day.
You too. Okay, I see you in my reading room, I believe. You're James SL.
Yes.
Okay. Ms. Comfort, did you need me to remove you from the virtual courtroom?
No, am I free to go?
Yep, you're free to go.
Thank you.
You're welcome.
Leave yourself to slow down. Where'd I go? No.
You got your pictures up, sir?
I believe I do.
Okay, so I just want you to show me what you mean about how he's plowing the snow, so I can understand what the basis of your lawsuit is.
Okay.
I'm sorry. Oh, sorry. My Zoom is waiting out real quick for Mr. Waller. I'll make it close. There you go.
Yeah. So I think this is USB, right? Yeah. I just took and open it. Whichever one you're trying to show us,
You should exit or exit this, as I don't see it, exit out of that. What you want to do is open the video on your computer.
Yeah, so I didn't hear stuff.
Exit out, stop the share. Now you open the video first. And then you want to go to share. Now that the video's up, make sure you share sound.
Okay, play.
Yes, please. Whose house is this that I'm looking at? You're in your window?
I'm in my window looking at.
And that's the neighbor's house?
Correct. That's down to
Okay.
the north. My house immediately to the north.
Tree comes down,
Yeah.
put the chair right there so that you can look out the window.
All right.
Okay, and so he's plowing it up against the fence, is that what you're saying? And you don't want him to plow, is it, whose property is it on? That he's plowing it against?
This is Mr. Lippincott property.
Okay. And you don't like the position in which he's plowing?
It's not that I don't like the positioning. There's two cases here, Your Honor. One, there was a drain tile that was pushed up against the fence from rainwater that was coming off Mr. Lippincott's roof. And then there's this snow situation where he's pushing snow to that exact location, concentrating in one area. So I've got the drain coming off the roof that's pushed against my fence. I've got the snow pushing up against my fence, and with the thawing of what we're having with the environmental issues, I'm subservient to his land. And I have a document here from the city and the next floor up, Alex performed for me about the topographic study of this area and how the natural flow transfers from his property to mine.
Okay.
And he is concentrating that snow in one area, and the law does not allow that. I have to be subservient to my neighbor's property if I'm lower than his, and I am lower than his, but he cannot concentrate snow. And that from his driveway, that driveway where Mr. Lippincott driveway is his house is 32 feet. There's another 6 foot of retaining wall. He's pushing an additional 40 feet past his driveway. Now I have another picture to show the definition of this in the summertime. And it's unreasonable for him to take, and I'll clearly dismiss the case if he agrees not to push the snow past that certain point. There's no reason for him to push snow past the sidewalk.
Who's Mr., you said Mr. Lippincott?
Mr. Lippincott.
Who's Mr. Lippincott?
Me.
Are you Mr. Lippincott? This is, you own this property?
Yeah.
Do you agree to stop pushing your snow there? Okay, so we can move on from that. He's not gonna agree.
Yeah.
That's all I asked. He's not gonna agree, so you can continue with your case. You said the law doesn't allow him to push his snow there?
I have to be subservient to properties that are higher than mine, and I am subservient to his. However, the law says that you can't, the natural flow law of doctrine that they adopted says that they cannot concentrate snow in any area to increase the flow of that water or natural flow.
What law is this?
It's the drain law for Michigan landowners. It's adopted. I don't know when the exact adoption. This is written up by Mr. Melvin Cotton and Elvin Schmidt, and there's some individuals.
Those two people don't write law. You need to cite the law for me. Is it a statute? Is it an ordinance?
It's a doctrine that has been established. What is the natural flow rule, or what is the natural flow rule in Michigan? Michigan's natural law doctrine states that if a property is at a higher elevation than your neighbors, the water that falls on your property most likely flows over your neighbor's land. You have the right to continue the natural flow, and your neighbor has a duty not to interfere with it. He's interfering with it by pushing snow 40 feet beyond the driveway.
My question, what was my question?
Cite the law. I don't have the exact law. Your Honor. I don't have the law. I just know that I've talked to several attorneys regarding this, and if he's increasing or concentrating the natural flow of water onto my property and causing damage, then he could be
What
liable.
proof do you have that him plowing his snow there is what's increasing the flow and causing a damage to your property? Because you got to provide evidence for me to review.
I have some more other pictures that I can show you.
No, I mean, I can clearly see that he's plowing the snow there, but that's not what I need. That's not the only thing I need to see. You now need to show me proof or evidence to support that his plowing snow there is what's causing damage to your property.
I have an estimate from a fence repair company.
I recognize you might have an estimate from a fence repair company. I now need you to show me that the repairs that you need for your fence were caused by him plowing snow there. Did you get an expert to come and look at the fence and for them to tell you that this is caused because there's snow being plowed here and it's causing extra water flow? You're not an expert to make that determination.
I've had 3 fence companies come out and state that and I've also had the city come out and say that there's puddling water in that area because I had to get the drain issue taken care of with Mr. Lippincott. Because they came out to see what he was doing.
So the city came out and they made an assessment stating what?
There was a drain tile that was up against my fence, and it was from Mr. Lippincott's side of the property, and the city came out, the plumber, and said, you have to issue a pressure to fix the fence, or to fix the, to position the drain properly. It was a sub-drain drain. I'm not gonna get into all that.
Got it. That none of these things support that his pushing snow there is what causes damage. You have to give me evidence to support that.
I'm not sure in terms of evidence other than just like a hydrologist or a topographic study. Is that what we're referring to?
You can call a witness that can support, that say, no, we reviewed this, we've done some research, and we know that this damage to the gate is being caused because the snow's there.
Then I would request more time to get an expert to make that assumption or opinion. I'm not an attorney. I've tried to settle the case. Even your court officer has to try to settle it. I've given a position on where I'm at.
So your claim is that you had to replace your fence here? Is it this fence?
It's not fixed.
Well, you have to replace the fence.
I have to fix there's some fence.
And what happened to the fence? Rotted or something? What happened?
No, the water has changed the soil, composition of the soil, so the fence is pushing over. There's another issue behind that, but that's just part of it, because again, there's two parts of this, and if I was gonna sue him for what I thought he was doing all the damage, it would be much more significant.
It wouldn't be in small claims, is what you're saying.
Well, it would be in small claims, but because both were in small claims, but there was damage done. It's not an exorbitant amount of damage, but there was damage done to my shed that was caused by excessive water being pushed.
What you believe to be excessive water being pushed,
I have
correct?
4 companies that say that, you know.
Okay, well, none of them are here.
None of them are here.
And you
I
can't
just
tell
have-
me,
I just
you
have-
can't tell me what they're saying because they're not here. That's hearsay.
That is hearsay, yes, ma'am. I do have them, but they're not here. and they're
So
on
you're
my show.
requesting time to bring them here or to bring a
Well, I mean,
witness?
if Mr. Brower is not willing to be reasonable on how far he pushes the snow out, then I have no choice.
We've already gone beyond. I thought we moved on. I thought we crossed that bridge already. He's
Well, then
not.
I'm asking
I
you-
asked him here on the record. He said, no, I don't want to hear about what he's willing to do. He's already told you what he's willing to do. He's got his arms crossed. I have no reason to believe he's negotiating in his mind, his statement. I don't think he's gonna change his mind about that. He's like, no, I'm not doing that.
Then I would
So
request
you,
more time.
okay,
Yeah.
and how much time do you think you're gonna request to get that? Because you've
I-
already had a hearing on this, at least back in May. And you were seeking how much money?
$1,000 in damages. I've spoken to, the companies that can provide these reports, but it takes a couple of weeks to get them prepared.
Okay, I think all the video and the pictures that you're showing are attached to the file. I'm not sure what this is a picture of. And you're requesting to continue this for a couple of weeks so you can call a witness? Correct?
Or obtain a report that shows where the water's flowing and how it flows.
You're
And
gonna do more than obtain a report because the report is still hearsay. You understand that?
I don't understand, as the report says the property, like, for example.
A hearsay is any out of court statement offered for the truth of the matter asserted. So so you submitted to me a report without the person who authored the report in court. That's an out of court statement. Okay,
And you won't accept that.
I'm not gonna accept an out of court statement.
Then I would need some time to see if I can get a witness to come in.
Okay. Okay. I'm gonna reset this.
Can I say something, Your Honor?
You may.
Why am I involved in this when I live 3 houses over and I'm hired to
why are you-
plow his land and he said to put it there?
Why are you involving him?
Last,
He's actually doing the plowing. He's the-
Oh, okay.
He's-
So
he's
you
the-
don't live here?
no, I live 3 houses over. The last judge said it's, I'm
You're-
the third
okay,
party.
You're, and you.
I'm
you-
hired to put it
okay.
there and he told me.
Mr. Lippincott, you hire him?
I don't hire him,
Well,
I mow his lawn. and-
Yeah, but you own the
summer, he
property that
plows
he's
my-
talking about though?
Pardon?
You own the property that Mr.
I do,
Okay, and do you, when he plows your snow, you tell him where to plow it?
yes, and it's not up against the fence, it's
No.
probably 6, 7, 8 feet away from the fence.
There's a big lake there. It goes all downhill to it and it don't hit his land.
But he's putting it where you asked him to put it,
Yeah.
the snow? You're suing the wrong person.
He was told that
He's the
last
wrong,
time.
he's the wrong party.
Well, he's actually doing the work.
It doesn't matter. He doesn't own the he doesn't own the property. You're suing the wrong person. Your case is dismissed.
Got 7,000 square feet of snow in my driveways. You know, I gotta put it somewhere. I can't not just pile it all in my driveway. So you're not gonna put it in the road. City's not gonna take care of it.
Okay, so you filed an appeal. I don't know if the magistrate told you that you're suing the wrong person. You just need to sue the right person. Then you can proceed with your case, not just appeal you suing the wrong
But
person.
he's already suing me too, so.
You already have a lawsuit against him, sir?
Yes, ma'am.
Oh, okay, well, then you continue with that. You're suing the wrong person. He's doing what he was told to do.
Thank you, Your Honor.
I do. Can I ask the judge a question once these two are dismissed regarding a separate matter outside of this case? Just a question regarding law? General question?
A general question, are you looking for legal advice?
No,
I
you're
know
not.
judges don't give legal
I'm
advice.
not asking for legal advice.
Okay, what is your question?
I would like to ask it in private.
I'm sorry?
I'd like to ask it in private. That's not.
We're not gonna have, the court's open to the public.
Right, in a case in which there's a small claims case that was dismissed, and the box was checked without prejudice. The
Okay.
magistrate had indicated that the defendant could, or the defendant could ask that the case be heard.
I'm sorry, the case was dismissed without prejudice and the magistrate asked.
That was the request.
Okay,
Right, and then the magistrate had indicated that the case could be, asked of the defendant to be heard. The basically the magistrate could ask the defendant to hear the case, if they wanted the defendant to hear the case. I'm just trying to dismiss it without prejudice, but the magistrate basically said, if I do that, then the defendant has the right for me to hear the case.
you wanted to dismiss it without prejudice? Is that what you're saying?
Yes.
Okay, yeah, because you're not looking to dismiss it with prejudice. With prejudice means you can't bring the case back
To the
against,
small claims court.
you can't sue him for the same thing because you're
So,
dismissing with
in
prejudice.
this court.
In any court, if you dismiss it with prejudice.
Okay, but she said if
But
there's another.
you're doing without prejudice,
Right, which is what I
meaning you
did.
want to maybe reissue it later.
Right,
And so that's why she granted opportunity for the case to be heard at that time,
okay,
because you weren't willing to dismiss it without prejudice.
okay.
I mean, with prejudice.
So if I'm dismissing with prejudice, then after that, I asked her, can I have another court hear the case? And she said, as long as they have jurisdiction.
Yeah, that's just the jurisdiction of the case.
I guess it's confusing when you say that. In jurisdiction, you can't.
Yeah, jurisdiction would have to be where did the issues take place, what jurisdiction? You can't just forum shop and go to any court you want to go to.
No, I understand that. But if there was an issue that this court couldn't.
Or it could be the amount in controversy, like you're suing him for $30,000, then you can seek jurisdiction over at the circuit court.
Okay.
Because the amount that you're seeking is above 25,000. But if you can't decide, you know what, I want to sue him in East Lansing District Court.
Okay, so it has to be like.
It has to be in the
Right.
jurisdiction in which the issues arose.
Okay. So by checking with prejudice, I can't come with to 54A District Court for the case. Sure. Thank you.
You're welcome. You're all set.
Thank you, Your Honor.
Thank you, Your Honor.